Today we're covering a topic that doesn't get talked about often but is extremely important. What happens if a property that you're buying gets damaged before you take possession? So I ran into this very situation earlier this year when I was representing a buyer client. A tree in the backyard fell over onto some power lines and pulled the service mast out of the roof of the home, causing some damage. The problem was that this happened after we had waived our conditions and the deal went firm, but before the possession of the property actually took place. So this is a pretty rare situation, but it definitely raises a lot of questions. Ownership of the property is currently changing hands, so who's actually responsible? How does the insurance work, and how do holdbacks work? Also, how does it differ if this damage happens before your conditions are waived as opposed to after your conditions are waived? We're going to walk through all of that and explain how things typically play out in a circumstance like this, so if ever this does happen to you, you'll know what to do. So first, let's set the stage so that we're clear on timing and terms. When purchasing a home in Calgary, you'll go through the sequence something like this. Your offer is accepted, but subject to conditions like inspection and financing. You then waive those conditions, and now you're locked in. Then you move towards closing and possession, but there can be a pretty big window of time before the final possession takes place. During that window between offer acceptance and the final closing date, the property is still legally owned by the seller. And this means that the seller remains responsible to maintain the property in the same condition that it was when your offer was accepted. Most of the time, this will be written directly into the purchase contract. You'll find a term that says the property is to be in substantially the same condition as when the offer was accepted. So in most cases, the property remains at the seller's risk until the final closing. From your perspective as the buyer, you want to know at what point things shift and how damage or a change in condition might affect your rights or protections. The difference between damage occurring before conditions are waived as opposed to after is a key distinction, and we'll go into each scenario in the next sections of this video. So let's imagine what would happen if damage occurs before you've waived conditions. In other words, you've made an offer, it's been accepted, and now you're in the condition phase. So maybe you're waiting on the home inspection, and during that time, some damage happens to the property. Maybe a major hailstorm, flooding, theft, whatever the damage might be. So because your conditions are still in place, you still have a great degree of protection, and you're not locked into this deal no matter what happens. Typically, if you're in the pre-possession period with conditions still in place, the buyer should be able to walk away from the contract. In this circumstance, you might say to yourself, okay, this property is not in the same condition as when I agreed to buy it. You can then ask the seller to complete repairs, you can renegotiate, or you can walk away. As a buyer in Calgary, you'll typically want to include an inspection condition on your purchase contract. With that condition in place, you can simply decide not to waive that condition and typically get your deposit back. From a practical standpoint, you'll want to document the damage, talk to your agent and your lawyer, and determine whether or not you're comfortable proceeding or you'd like to renegotiate a different outcome. The seller remains on the hook to maintain the property during that interim period unless it's specified in the contract otherwise, but in most cases, it will remain on the seller in circumstances like this. So this was the situation that my client found himself in, and it's arguably the trickiest. Your conditions have been waived, meaning you're committed to buy, but you haven't taken possession of the property yet. It's yours, but not quite. Then something happens to the property. Could be anything from a roof leak to flooding to a tree falling, that kind of thing. In this case, your rights are a little different and your exposure is higher. Typically, in this type of circumstance, you can't just walk away from the deal. What you're looking at now is to ensure that the damage is accounted for so that you're not left holding the bag. So as mentioned earlier, your purchase contract should have a term within it that stipulates that the seller maintains the property until the transaction is complete. So from your perspective as the buyer, you still do have some leverage. One, you can ask the seller to repair the damage before closing. Two, you can ask for a credit or a reduction in the purchase price to account for the damage to the home. Or three, you can negotiate a holdback where funds are retained at closing until the seller completes repairs. Whatever you choose to do at this stage, don't panic and try to walk out on the deal. Doing this can cause all kinds of legal issues and can cost you as the buyer. You still got legal protections in place, so don't stress too much, but because you've waived conditions, you don't necessarily have the right to terminate just because there's been some damage to the property. So finally, let's talk about what's probably the worst case scenario for a buyer. Damage happens after you've taken possession. Well, at this point, the property is yours, so unless your contract or a warranty says otherwise, you're on the hook for the damages. Any post-closing issues are likely the responsibility of the buyer, unless you can prove that the seller was deliberately deceptive or misleading about any defects on the property. So in practical terms, unless you have some reason to suspect deliberate misrepresentation, you're pretty much on the hook. I mean, you do own the house now. So really what this means is that you should make certain that you're going into possession with your eyes open. Your inspections have been done, your contract has been reviewed, and your insurance is in place. So let's talk about the tools that you have available to you and the best practices to keep yourself protected in each of these circumstances. So we've mentioned that you have the option of doing what's called a holdback. And a holdback is where you agree to hold back some of the purchase funds until the seller completes specified repairs or can prove to you that the damage has been remedied. Holdbacks are typically handled through your real estate attorney, so that's who you'll need to talk to in the event that you're going to need to pursue one of these. From an insurance perspective, you're going to want the seller's insurance to remain in force up until possession date, and then your insurance to kick in on possession date. One other thing that seems minor but can make a big difference is to ensure that you have your final walkthrough of the property as close to the possession date as possible. Make sure you document the condition of the property with photo and video, and confirm with your agent or lawyer that the contract does cover you in the event of these types of issues. Being clear and asking good questions from the beginning will help you avoid any big issues down the road. So there you have it. If damage occurs before you waive conditions, you have more flexibility and more options. And if the damage happens after you've waived conditions but before possession, you're committed, but you still have options like holdbacks, repair negotiations, and credits. Once you've taken possession, the risk is mostly yours, unless you're in a circumstance where there was some kind of deliberate misrepresentation of the property. So I hope that you found this video helpful. Please don't forget to like and subscribe, and I will see you in the next one.